When the Constitution of India was drafted, it wasn't merely a legal text. It was a moral document. It didn't just tell us what powers the state would have, but how those powers must be used. And that invisible compass, that idea that governance must rest on an inner discipline, came to be called constitutional morality. When you speak of morality, most people think of personal conduct. What's right, what's wrong, what your parents taught you, what your religion taught you. But when we say constitutional morality, we enter a very different battlefield. This isn't about virtue, it's about power. Because whoever defines morality inside a constitution defines the limits of freedom itself. Now here's the thing, the phrase constitutional morality wasn't invented by a judge. It was coined by B.R. Ambedkar, and when he used it, he didn't mean morality as in righteousness. He meant discipline, the self-restraint needed to live by rules when you have power to break them. Ambedkar said, and I quote, "Constitutional morality is not a natural sentiment. It has to be cultivated. We must learn to subordinate our social morality to constitutional morality." He was warning us. India's real danger isn't foreign invasion anymore. It's a native instinct to break the rules when they get in our way. But here's what happened. Over time, constitutional morality, once a guardrail against abuse of power, became a sword in the hands of powerful. Judges began invoking it, not to restrain the state, but to reshape society. And that's when the controversy began. Because whenever the judiciary steps in to decide what morality means, it isn't just interpreting law. It's rewriting the social contract. So in this lecture, part of our Constitution Dialogue series, we will trace that entire journey from Ambedkar's cautious optimism to today's fierce debates, from Sabarimala to same-sex marriage, from triple talaq to hijab. We will ask a simple, uncomfortable question. Is constitutional morality still a living idea, or has it become a form of judicial overreach? We will see how the idea was born in the Constituent Assembly, forgotten for decades, resurrected by the courts, and now weaponized in moral wars that divide India's soul. And most importantly, we will ask who gets to decide what's moral for 1.4 billion people. Let's begin. Act 1 of this lecture is about the birth of the phrase, Ambedkar's warning and Nehru's dilemma. Let's go back to the 1947, a country just freed from empire, still bleeding from partition, and yet tasked with building the world's largest democracy from scratch. Everyone in that room, Ambedkar, Nehru, Patel, Rajendra Prasad, they weren't just drafting a legal document. They were designing an emotional system for an ancient civilization. Now imagine the mood. The fear wasn't that the British might return. The fear was that Indians themselves might not be able to handle freedom. Ambedkar saw it clearly, he said, and listened carefully. Constitutional morality is not a natural sentiment. It has to be cultivated. We must learn to subordinate our social morality to constitutional morality. He was saying India already has morality, caste morality, religious morality, community morality. But what we lack is constitutional morality, the discipline to respect the rules even when they go against our social instinct. Because Ambedkar had seen it firsthand, the tyranny of majorities, the silencing of untouchables, and the arrogance of those who think they are born to rule. He feared that once political power shifted from the British to the Indian elite, the same patterns of oppression would simply reappear, only just now justified in the name of culture, religion, or majority sentiment. So for Ambedkar, constitutional morality was a restraint on the mob. It was the idea that the law, not sentiment, should govern the republic. Now, Nehru had a different anxiety. He believed democracy couldn't survive without a moral conviction. He worried about the empty formalism of institutions, that rules alone weren't enough. He said once, quote, "A constitution may provide machinery, but the spirit of the people must keep it alive." So you had Ambedkar warning against social morality, overwhelming constitutional order, and you had Nehru reminding that rules without moral substance would collapse into cynicism. This tension between discipline and conscience, law and morality, is what gave birth to the phrase constitutional morality. It was never meant as a moral sermon. It was a civil ethic. A way to ensure that the republic behaves better than the instincts of its people. But here's the irony. Ambedkar's phrase never made it into the operational part of the constitution. You won't find constitutional morality mentioned anywhere in the articles. It was spoken, not written. A moral compass, left as an unwritten code. Ambedkar knew that societies like ours, built on hierarchy, not equality, would take generations to internalize constitutional discipline. He warned that democracy in India is only a top dressing on an undemocratic soil. He meant we have democratic institutions, but not yet democratic instincts. And that's where constitutional morality was supposed to come in as a kind of civic religion. But after the constitution was adopted in 1950, the phrase vanished completely. The courts didn't use it, the politicians ignored it, the public never even heard it. For almost 60 years, constitutional morality lay buried in the archives of the Constituent Assembly debates, a forgotten sermon in a nation too busy surviving. It took nearly half a century and a moral crisis for the phrase to return. But before we get there, we need to understand why it disappeared. See, the 1950s and 60s were decades of nation-building anxiety. The government wanted unity, not dissent, stability, not moral debates. Free speech was restricted within a year of the constitution. Preventive detention laws were introduced. The press was tamed. The judiciary, in early years, stood as a cautious observer. Nehru's dream was a modern secular India, but it was an India that often sacrificed liberty at the altar of progress. Ambedkar's concept of constitutional morality, which demanded moral discipline against power, simply didn't fit that mood. And so, for decades, India functioned under what I would call constitutional legality, not constitutional morality. We obeyed the text, but forgot the spirit. But here's the twist. When the phrase re-emerged, it didn't come back as Ambedkar's idea of restraint. It came back as a judicial doctrine of transformation. Courts began saying, if the majority's morality violates constitutional values, we, the judges, will correct it, using constitutional morality. It was no longer about restraining power, it was about exercising power. And that changed everything. Because now, every time society is divided, religion versus rights, tradition versus equality, custom versus conscience, the courts stand up and say, we will decide what morality means for the constitution. Which brings us to the second phase of our story. How constitutional morality, once buried, was resurrected by the judiciary as both a shield and a sword. Act 2 of this lecture is about the forgotten years, silence before resurrection. For almost half a century, the phrase constitutional morality slept like an unopened file in a forgotten archive. From 1950 to 2009, not a single major Supreme Court judgment used it. The word morality appeared often, but it always meant public morality. And public morality in Indian courts almost always meant the morality of the majority. Think about that. For a country built on the promise of equality, the courts rarely questioned the moral assumptions of society. Instead, they mirrored them. The 1950s were Nehru's years of faith in planning, in rationalism, in centralization. The constitution was seen as an engineering manual, not a living text. Judges were cautious, parliament was supreme. In 1962, the Supreme Court upheld the First Amendment's restrictions on free speech. In 1971, it upheld bank nationalization. In 1975, during the emergency, it said that even if constitutional rights were suspended, the state's word was final. These weren't moral movements, they were political calculations dressed as legality. The Republic had law, but not yet a conscience. It's almost poetic, really. Ambedkar had warned that democracy without constitutional morality becomes a ritual of obedience. And that's exactly what we became, obedient. We followed the letter of the law even when the spirit was violated. We built grand institutions, Parliament, Supreme Court, Election Commission, but forgot that these institutions were only as moral as the people who ran them. Then came 1975, the emergency. The state censored newspapers, Opposition leaders were jailed. The constitution was amended overnight. And for the first time, India saw what Ambedkar had feared most: the complete collapse of moral restraint. One judge, Justice H.R. Khanna, stood against it. In ADM Jabalpur versus Shivkant Shukla, he dissented, saying, even in emergency, life and liberty cannot be suspended. He lost his chance to become Chief Justice for that stand. That dissent, silent, lonely, almost forgotten, was the first spark of constitutional morality returning to Indian soil, because it reminded everyone the constitution isn't just a book of rules, it's a mirror, and when power stares into that mirror long enough, it must see its own reflection. After the emergency ended, the judiciary began to evolve a new language. It rediscovered the idea that the Indian constitution has a basic structure, something Parliament itself cannot destroy. That was the Keshavananda Bharati judgment of 1973, a turning point. But even then, nobody used the phrase constitutional morality, not yet, because the society itself hadn't matured to accept it. We were still too obsessed with identity, caste, religion, language to think in moral universals. It took another 3 decades and a cultural shift for that idea to return. By the early 2000s, India had changed. Liberalization had created a confident middle class. Technology gave everyone a voice, but it also brought friction. Tradition versus modernity, faith versus rights, culture versus equality. Every courtroom battle now looked like a cultural war, and suddenly, judges found themselves not just interpreting the law, but defining the nation's morality. That's when constitutional morality came back, not as Ambedkar's civic virtue, but as a judiciary's weapon of transformation. It first appeared in the Nas Foundation case 2009, the Delhi High Court's landmark judgment, decriminalizing homosexuality. The judges wrote, if there is any morality that can claim to be constitutional, is constitutional morality, not public morality. That one sentence changed the moral grammar of Indian law. It told the nation morality is no longer what the majority feels, it's what the constitution envisions. Think about the weight of that shift. For centuries, Indian morality was defined by community, by what the elders, the priests, the majority said was right. Now, for the first time, morality was defined by a document and by the court interpreting it. It was evolutionary and dangerous. Evolutionary because it gave voice to those whom society had silenced. Dangerous because it gave unelected judges the moral authority of prophets. And that duality, that tension is exactly what the next phase of our story explores. Because from Nas Foundation onwards, constitutional morality became the favorite phrase of Supreme Court in every socially divisive case. In Sabarimala, it was invoked to strike down the exclusion of women from temples. In the Triple Talaq case, it was used to uphold gender equality. In the same-sex marriage petitions, it became the moral battlefield between individual liberty and social consensus. What Ambedkar designed as a civic restraint had become a judicial crusade. So the question is, when judges use constitutional morality to override traditions, are they guarding the constitution or rewriting it? That question will decide the next century of Indian democracy. And that takes us to the next act or the chapter, the birth of phrase that became the conscience and controversy of the modern court. Act 3 of this lecture is about the resurrection, from Ambedkar's idea to the judiciary's creed. Every republic has its turning points, moments when a single phrase changes the course of its moral compass. For India, that phrase was constitutional morality, and its resurrection began not in parliament, not in politics, but in the courtroom. Let's rewind to the year 2009. A small, courageous NGO called Nas Foundation challenged Section 377 of Indian Penal Code, a Victorian law that criminalized homosexuality. They argued that this law violated Article 14, equality before law, Article 15, protection from discrimination, and Article 21, the right to life and dignity. But the real weapon wasn't just legal, it was moral. The Delhi High Court, in a judgment written by Justice A.P. Shah and Justice S. Muralidhar, invoked the phrase India hadn't heard in decades. If there is any morality that can claim to be constitutional, it is constitutional morality and not public morality. That sentence, calm, almost academic, struck like thunder through India's cultural ceiling. It redefined the battlefield because until then, morality meant what the majority approved. Now, morality was anchored in the constitution, a moral code born not of numbers but of values. What the judges really said was this: the constitution is not a mirror of society, it's a map of what society ought to become. That's a profound shift. It turns the constitution into a teacher and the judiciary into its interpreter, philosopher, and sometimes missionary. And here's where the story becomes complex, almost cinematic. In 2013, the Supreme Court overturned the Nas Foundation verdict. Justice Singhvi and Justice Mukhopadhyay said, a minuscule fraction of the country's population constitutes lesbians, gays, bisexuals, or transgenders, and therefore Section 377 does not suffer from constitutional infirmity. Minuscule fraction. Just 4 words, but they revealed something deep about how India viewed rights. We still measured justice by arithmetic, not by principles. And yet, history has a strange sense of timing. Within a few years, India had changed again. Socially, digitally, politically, the language of rights had matured. The courts were under pressure to reclaim their moral leadership. Then came to 2018, the year of judicial resurrection. The Navtej Singh Johar judgment struck down Section 377 once again, this time decisively. Justice Chandrachud, in his separate opinion, wrote words that will echo for generations. Constitutional morality requires that this court must act as a counter-majoritarian institution to ensure that rights are not sacrificed at the altar of social or religious morality. That single line redefined the moral architecture of Indian democracy. It declared that the judiciary was not simply an interpreter of law, it was the guardian of the republic's soul. From Nas Foundation to Navtej Johar, constitutional morality became a kind of civic religion. Judges quoted it with reverence, scholars debated its boundaries, politicians resented its audacity, and yet, ordinary citizens began to feel something new: that the Constitution wasn't just a document in the archives. It was a living presence, speaking through judgments, shaping daily life. But like all revolutions, it came with unintended consequences. When you give judiciary the power to decide what morality means, you also give it the power to decide which values are superior and which traditions must die. That's exactly what happened in Sabarimala. In 2018, the Supreme Court struck down the ban on women of menstruating age from entering the Sabarimala temple. The court invoked again constitutional morality. Justice Chandrachud wrote, the practice of excluding women is a form of untouchability. Justice Indu Malhotra in dissent warned, not all practices can be judged by the yardstick of constitutional morality. The Constitution does not permit the court to determine which religious practices are rational. And that dissent, much like Justice Khanna's during the emergency, captured a deeper anxiety. Was the court protecting rights or imposing its own vision of right and wrong? Because when judges invoke morality, they walk a thin line. If they hesitate, the people suffer. If they overreach, democracy trembles. After Sabarimala came triple talaq, right to privacy, adultery, and most recently, the same-sex marriage hearings. Each case became a moral stage, and each judgment a philosophical essay on India should evolve. Now let's pause and ask something uncomfortable. When the judiciary quotes Ambedkar and speaks of constitutional morality, is it channeling his original intent? Ambedkar's morality was disciplinary, not doctrinal. He wanted citizens, especially those in power, to restrain themselves through reason, not passion. He never meant for morality to become a judicial decree. He feared precisely what's happening now, that moral authority, once centralized, becomes another form of dominance. And yet, paradoxically, without that very moral authority, minorities, women, and dissenters would still be trapped in the tyranny of tradition. So we are left with a haunting paradox. India needs constitutional morality to protect the weak, but must constantly guard against it becoming moral imperialism. That's the tightrope our judges now walk. They're not just interpreters of law, They have become curators of our collective conscience. Every word they write reshapes the nation's self image. Every moral verdict changes how India imagines justice. The real question now isn't what the constitutional morality means, it's who gets to define it. The framers wrote it, the judges revived it, the citizens must now reclaim it. Because if morality becomes monopoly, then liberty becomes permission. And that brings us to our next act of this lecture, the age of confrontation, when morality meets politics and ideals collide with power. Constitutional morality is not a natural sentiment, it has to be cultivated. We must realize that our political democracy cannot last unless there lies at the base of its social democracy. Act 4 of this lecture is about the morality on the bench, when judges became prophets. There is a moment in every republic when judges stop being mere interpreters of law and start becoming interpreters of civilization. In India, that moment arrived quietly, case by case, until suddenly it wasn't law anymore, it was prophecy. Let's begin with the case that turned moral philosophy into judicial vocabulary, Sabarimala. The question was deceptively simple. Can women of menstruating age enter the Sabarimala temple in Kerala, where the deity Lord Ayappa is worshipped as a celibate god? The temple's tradition said no, but the constitution said equality. Now, most societies would debate this through the legislature, but in India, we took it to the courtroom, where theology met Article 25 and tradition faced Article 14. The judgment split the nation. Justice Chanchud's opinion, invoking constitutional morality, declared, the Constitution places individual dignity above all forms of social morality. Justice Indu Malhotra dissented, and her words cut through the marble of judicial confidence. Issues of deep religious faith and sentiments should not ordinarily be interfered with by any courts. That dissent became the people's verdict. Temples saw protests. Pilgrims resisted what they called judicial intrusion into the sacred, and here's the irony. A verdict meant to protect women's rights ended up dividing women themselves between faith and freedom. This was not a clash of the genders. It was a clash of moral justifications or jurisdictions. Who decides what's sacred, and the believer or the bench? Next came the Triple Talaq case, Saira Bano versus Union of India. A Muslim woman challenged the instant divorce practice. The court struck it down. Not because Parliament acted, but because the judges felt that constitutional morality could not coexist with personal law. The ruling gave Muslim women justice, but it also raised the same unsettling question. When does judicial morality cross into cultural engineering? By 2017, the judiciary wasn't just interpreting law, it was editing India's moral code. Take right to privacy, a landmark judgment. Justice Chanchud again, this time leading the bench, called privacy the constitutional core of human dignity. A brilliant judgment, no doubt, but beneath it lay something profound. The court was teaching the Republic how to feel, not just how to function. And then, Joseph Shine versus Union of India case, the adultery one. Section 497 of the IPC, a colonial law, punished men for adultery but treated women as property. The court struck it down. Justice Mishra said, the husband is not the master of his wife. Justice Nariman invoked autonomy as the essence of dignity. Justice Chanchud went further. Society has no stake in moral policing. And yet, in the same breath, the court became the ultimate moral policeman of the Constitution. By 2018, constitutional morality had become a judicial anthem, and every major verdict hummed to its tune. Then came the same-sex marriage hearings 2023, a constitution bench. India now more digital, more polarized, more performative than ever before. Petitioners sought legal recognition of queer marriage under the Special Marriage Act. Their arguments were heartfelt: dignity, equality, privacy, choice, all constitutional, all human. But the court stopped short. Chief Justice Chanchud said, there is no unqualified right to marriage under the Constitution. Justice Kaul agreed, but reminded the state that love cannot be illegal. It was a restrained judgment, yet it revealed something critical: that constitutional morality, once a sword, had now become a shield used by the court to defend itself from the charge of overreach. So, where does that leave us? We now live in a republic where morality has migrated from the temple to the courtroom, from the village square to the PDF of a judgment. Our judges speak in the language once reserved for philosophers. Their words are quoted in college debates, printed on placards, and weaponized in television studios. But beneath this moral awakening lies a subtle danger, the danger of judicial theocracy. Because when courts begin to dictate moral truth, they inevitably begin to choose which truths are tolerable. We saw this during the Hijab controversy in Karnataka. The question wasn't just about clothing, it was about constitutional space. Can a student wear a hijab in a government's classroom? Does freedom of religion yield to uniformity? The High Court said, wearing a hijab is not essential religious practice. The phrase essential religious practice has become one of the most weaponized doctrines in Indian jurisprudence. Think about it. A secular court decides what is essential to a religion. A constitutional morality decides what is legitimate in faith. And a citizen standing between both feels like a stranger to its own beliefs. This is the price of moral governance, even when done in the name of liberty. But let's not misunderstand the judiciary. These judges aren't villains. They are navigators of a ship that drifts between chaos and conscience. In a nation where parliament hesitates and executive often bends to populism, the judiciary steps in, sometimes reluctantly, sometimes boldly, to preserve the republic's soul. Tragedy is every time it does so, it is accused of judicial activism, of moral elitism, of playing God, and perhaps sometimes rightly so. Because morality, when spoken from the bench, carries the authority of law and the seduction of virtue. And that combination is both powerful and perilous. And here we are, more than 75 years after the Constitution came into force, still arguing about who gets to define right and wrong. The framers designed a legal document. The judiciary turned it into a moral scripture, and now the people must decide whether to follow it, challenge it, or rewrite its gospel. This is where Ambedkar's warnings rings louder than ever. Constitutional morality is not a natural sentiment. It has to be cultivated. He didn't say by judges, he said by citizens. Because in the end, a democracy survives not by who wins in court, but by whether its people can live with the judgments passed upon their conscience. We have entered an era where morality has a citation, faith has a footnote, and liberty has to be justified paragraph by paragraph. This is not a decline of law, it is a moral adolescence of our nations, learning what freedom truly means. So the next time you read a judgment, don't ask whether it's correct, ask whether it's humble. Because when the law claims moral supremacy, it risks losing moral authority. Act 5 of this lecture is about the politics of morality. When the state learns from the bench. There's a strange thing about power. It rarely invents morality. It simply learns how to weaponize someone else's. When the judiciary began invoking constitutional morality, it wasn't just interpreting the constitution. It was teaching the state a new language of control. And the political class was listening closely. Let's begin with the paradox. The same phrase, constitutional morality, that once protected the citizens from majoritarian impulses, is now being used by the government to discipline dissent. Remember Ambedkar's original context. He said, constitutional morality means the willingness to abide by the norms of the constitution, even when they restrict your power. But in our times, those in power use constitutional morality not to restrain themselves, but to justify whether or whatever serves their moral narrative. Take free speech. Every government since independence has struggled with it. But in the digital era, control doesn't come through censorship alone. It comes through moral framing. So when a film, a tweet, or a stand-up act is silenced, the justification isn't we disagree. It's we are protecting public morality. It's we are preserving constitutional values. A neat trick, because when morality is constitutionalized, dissent becomes immoral. Let's take an example. In 2020, comedians and writers across India found their shows cancelled, not because of court orders, but because of administrative permissions denied on grounds of public order. The state said it was protecting harmony, but really, it was policing taste. This is not new. During the emergency in 1975, censorship was open. In today's republic, it's moralized. Now consider education and the cultural curriculum. Textbooks are being rewritten. History is revised, language is ranked by virtue of nationalism. When questioned, the response is constitutional morality requires us to protect national unity. Again, the phrase returns, not as philosophy but as permission. The Sabarimala verdict, which we discussed earlier, taught the state something crucial, that morality can be made constitutional and constitutionalism can be made moral. Soon after, states began invoking public morality to restrict what people could eat, wear, read, or watch, and each time the justification wasn't faith, it was values. This blurring of constitutional morality and state morality is one of the most dangerous transformations in a republic. Because once the government starts claiming the moral ground of the constitution, citizens lose the right to challenge it without appearing anti-constitutional. Take the hijab case again. After the Karnataka High Court upheld the ban, state officials declared that the decision upheld constitutional morality. But what does that mean? Whose morality was it, the constitution's or the state's? When Ambedkar spoke of constitutional morality, he wasn't talking about imposing uniformity. He was warning against the tyranny of conformity. Now look at the same-sex marriage debate in 2023, when the Supreme Court stopped short of recognizing queer marriages. The government said, quote, only Parliament can decide such social questions, unquote. It then added that India has its own moral fabric. The phrase sounded familiar, like a political mix of judicial morality. In the courtroom, constitutional morality is invoked to expand freedom. In the political arena, it's invoked to restrict it. This is the heart of the problem. When morality becomes the grammar of governance, every disagreement sounds like blasphemy. We see this moral governance in multiple sectors, from the IT rules that compel platforms to remove offensive content to laws that monitor what is fake or misleading. On papers, these are rules for responsible discourse. In practice, they are levers of selective silence. The digital state now wears the robe of constitutional virtue, while quietly deciding which voices are worthy of being heard. Let's step back for a moment. Why is morality so attractive to those in power? Because legality can be contested, morality cannot. A law can be challenged in court, but a moral argument disarms you before you even begin. Try arguing against something in the national interest. Try questioning something done for the greater good. You instantly become the villain of your own democracy. That's how a republic drifts from democracy to tutelage, where citizens are no longer equals but pupils of the state's moral instruction. Let me tell you something. Ambedkar understood better than anyone. He said, quote, democracy in India is only a top dressing on an undemocratic soil. He wasn't insulting us, he was diagnosing us. He saw that we are people of moral comfortable. He saw that we are a people more comfortable with obedience than disagreement. And that's precisely why the fusion of moralism and authority feels so natural here. We confuse virtue with validation. We mistake moral posturing for governance. Now think of how this plays out internationally. Whenever global organizations criticize India's press freedom, human rights, or laws, the official response often invokes our constitutional morality or civilizational morality. A way of saying our constitution has its own moral DNA. Don't lecture us. This nationalist moral narrative is powerful, but it also isolates us from global democratic norms. Because constitutional morality was never about cultural exceptionalism. It was about universal restraint. The question before us now isn't whether the judiciary or the government is moral. It's whether morality itself can remain constitutional once it becomes an instrument of power. The answer lies not in the courts or ministries but in the public sphere, in whether citizens can distinguish morality from manipulation. In truth, constitutional morality was meant to be a compass, not a weapon. It was meant to remind those in power that the law is discipline, not a pulpit. When that compass starts pointing wherever authority desires, we no longer have morality. We have moral theatre. So when you hear a leader say, as per constitutional morality, listen carefully and ask, whose morality, whose constitution? Because the moment those words stop meaning restraint, they start meaning justification. That's how moral republics become moral empires, where virtue is dictated, not debated. The framers of our constitution gave us the machinery of law. They trusted us to supply the spirit of morality. Today we have reversed it. The state supplies the morality, and the citizens must supply obedience. We are now a republic where everyone speaks of constitutional morality, but very few practice constitutional humility. Axis of this lecture is about the future, reclaiming moral liberty. Let's be honest, every age of power believes it's righteous. Every ruler thinks his morality is constitutional, and every generation, including ours, believes it's free. But here's the uncomfortable truth. We are free only to the extent that we dare to disagree. In the name of unity, we have started treating dissent like disease. In the name of morality, we have turned virtue into censorship. And in the name of constitutionalism, we have built an empire of legality without the soul of liberty. So, the question before us is no longer what constitutional morality means. It's how do we reclaim it? Because if morality itself has become the state's instrument, then reclaiming it becomes an act of rebellion, a moral rebellion. To reclaim moral liberty, we must do three things: revive Ambedkar's idea, redefine the citizen's conscience, and reform the judiciary's role in moral adjudication. Let's unpack them one by one. First, reviving Ambedkar's idea. Ambedkar's constitutional morality wasn't about preaching virtue. It was about disciplining power. He borrowed the phrase from George Grote's History of Greece, where constitutional morality meant a deep respect for the forms and restraints of the constitution. Ambedkar warned, quote, without constitutional morality, the machinery of democracy will go to pieces, unquote. Notice his choice of words, machinery. He didn't say soul or spirit. He was describing a system, not a sermon. In Ambedkar's vision, morality wasn't about the citizen obeying the state. It was about the state obeying the constitution. Today, that order has reversed. Everywhere you look, from parliament to the police, the state speaks the language of moral virtue, but not constitutional restraint. When Ambedkar said, cultivate constitutional morality, he meant make the law your conscience, not your convenience. Imagine if ministers, judges, and citizens lived by that line. Half our crisis would vanish before they reach the courts. Second is about redefining the citizen's conscience. Now let's talk about us, the citizens. We often talk about morality as something given to us by religion, culture, government, or law. But a republic flips that. In a republic, morality is supposed to flow from citizens upward, not downward from authority. That's why the constitution begins with we, the people. But look around, how many of us actually practice moral liberty? We self-censor our thoughts. We troll instead of debating. We surrender our conscience to ideology and then claim to defend the constitution. This is what I call moral outsourcing. We outsource judgment to our political tribe, our community, our favorite anchor, or our algorithm. And every time we do, we weaken the republic, because the republic survives only on self-governing minds. Constitutional morality demands that citizens be capable of moral reasoning, not just moral obedience. That means questioning our side, not just theirs. That means defending rights we personally dislike. Because if rights depend on popularity, they are not rights anymore, they are privileges. Think about it next time someone says, ban that film, cancel the comedian, silence that voice. A democracy dies not when it bans speech, but when citizens begin to enjoy watching it banned. Third is reforming judicial morality. Now the third part, the judiciary. In the last decade, the Supreme Court has often stood as a moral compass of the nation. Sometimes rightly so. Like in Nafte-Johar 2018 case, when it struck down section 377 and said, and I quote, Constitutional morality cannot be martyred at the altar of social morality. That was moral courage, not moral posturing. But there have been other movements like the Ayodhya verdict 2019 or the same-sex marriage case 2023, where the line between legal reasoning and moral balancing became blurred. Judicial morality must never become judicial paternalism, because once judges start deciding what's moral, they start substituting wisdom with virtue, and virtue, unlike law, has no appeal mechanism. The court's real strength lies in moral clarity, not moral authority. To protect that clarity, it must rediscover restraint. Restraint not because it fears backlash, but because democracy demands humility from all power. Even the power to interpret justice itself. Justice Chandrachud once said, "Constitutional morality requires that we value the plurality of beliefs, not uniformity of opinions." That line is gold. If the judiciary clings to it, really lives by it, then it can anchor morality without owning it. Now let's talk about the global context. Let's step outside India for a moment. Around the world, constitutional morality is being tested. From America's culture war to Europe's immigration crisis, everywhere courts are being accused of moral activism. Everywhere politicians are claiming moral monopoly. It's not just our problem, it's a global pattern. There is something unique about India. We are the only large democracy that wrote morality into its constitution through words like fraternity, dignity, and liberty of thought. Those weren't ornamental words, they were moral instructions to the future. That future is us, and whether those words survive depends not only on parliament or the bench, but on how we the people carry moral liberty in our daily lives. So let's imagine a new oath, not for ministers or judges, but for ordinary citizens. An oath that says, "I will not let morality become an accuse of hate. I will not surrender my conscience to convenience. I will defend the right to disagree, even when I disagree with it." That's what reclaiming moral liberty means. Not rebellion against the state, but reclamation of the inner republic. Because remember this, you can't build a moral nation through fear, and you can't defend a free constitution through obedience. Freedom needs friction, liberty needs dissent, and morality, true morality, needs humility. When the framers finished drafting the constitution, Nehru said in the assembly, "We are little men serving great ideals." Those words still ring true because constitutional morality was never about perfection. It was about striving, failing, trying again. In the age of hashtags and algorithms, we have turned morality into performance. But the Constitution reminds us the truest morality is conduct. It's not about how loudly you proclaim your virtue, but how quietly you uphold another's rights. And that's where we find the real test of this republic, not in courts or campaigns, but in the conscience of its citizens. So the next time someone tells you that morality and democracy are at odds, remember this: constitutional morality isn't the enemy of freedom, it's the discipline that makes freedom possible. Because without that discipline, liberty becomes noise and democracy becomes theatre. I am Amod Bidhuri, and this is the next hearing where the constitution is in text. It's a mirror, and what you see in it depends on the morality you brings to it. We will meet again in the next hearing.